From KQED News, this is special live coverage of today's Ninth Circuit Court of Appeals hearing on President Trump's executive order on travel and immigration. Good evening, I'm Scott Schaefer. Earlier today, a three-judge panel of the Ninth Circuit heard oral arguments in a case known as States of Washington and Minnesota versus Trump. At issue, the suspension of President Trump's travel ban by a lower court judge in Seattle. On behalf of the president, a Department of Justice attorney argued that the Seattle judge overstepped his authority, that those travel restrictions on refugees and others entering the country should go into effect. Arguing on the other side, the state of Washington, which last Friday won a restraining order from a U.S. District Court judge temporarily suspending the president's order. And joining us now is Joe Miller. He's executive director of the United States Justice Foundation. They're a nonprofit that works to advance a conservative, what they call a liberty agenda. And Joe Miller, you filed an amicus brief on behalf of several groups, including Citizens United and Gun Owners of America. What is your position? Why do you think that this lower court order should be reversed and this ban should go into place?
Well, of course, we aren't the only entity that said that. There's a district court judge in Massachusetts that ruled on this as well and said that, look, the president has plenary power in this area. The immigration statute in which the president acted gives him almost unlimited power to make limits on those coming into the country, especially those that haven't been here before. I mean, this is a class of people that isn't even entitled to constitutional protections, and yet we're talking about First Amendment protections and the like. The reality is the president has near unlimited power to do what he's done. It should be upheld. In fact, the injunction should be struck down, and I think that the judge at the district court level and the Ninth Circuit has made an error in this, a very, very significant error.
Well,
and there's, a long history behind this. I mean, this is not just, the judge over in the District Court of Massachusetts saying that, in fact, the president had the power to do it. This is 125 years of jurisprudence.
And Joe Miller, you argue that aliens have no rights under the Constitution. But what about their relatives in the United States who are citizens? Someone, say, whose husband would be prevented from coming from Syria. Surely they have rights.
Certainly, there have been arguments made before the federal courts that, hey, if you're getting married or have been married to an alien, that person should be able to advance its rights. I mean, there have been cases where they've been found to have standing, but fortunately, at least for President Trump in this case, those cases have almost universally been turned down. In other words, that still the president's plenary power is so broad that it can still prevent, even where a U.S. citizen may be affected by that decision, the president still has the power, given what's been allocated to him by the Congress, to make those decisions, especially ones that are based upon the national interest, the national security interest. I mean,
let me just bring Rory Little in here, if I could, because we're short on time. I apologize for cutting you off. We'll come back to you in a moment. But Rory Little, what about his point that about this judge in Boston who ruled in favor of the Trump administration and the ban on travel, the restrictions on travel? Why was that order sort of overruled in a sense by what happened out of Seattle last week?
Well, you have different plaintiffs, the state of Washington and the state of Minnesota, as opposed to two individuals in Boston. And the Supreme Court, Judge Clifton, the Republican appointee today, said there are cases in the immigration area where they have given standing to people to challenge the president's immigration authority, Kerry versus Din and Mandel. It was Judge Clifton who was asking the other side about these cases. So it's just not true that there's sort of an unbroken history of presidential power here. Certainly the president has a lot of power, a lot of authority. But in this case, if there was religious animus, I think there could be a serious problem.
And so those comments about maybe giving some favoritism to Christians could come back to haunt the president.
They're certainly trying to use them, yeah.
Before I let you go, Joe Miller, there was some suggestion that perhaps this three-judge panel should narrow the ruling a bit. Would that satisfy you and the groups that you represent?
No, I think that'd be a restriction on presidential power where one is not intended by Congress. I would also like to note to the professor's comment about the potential religious animus. It's notable that Kuwait has actually implemented a travel ban from 5 of the same 7 countries that were covered by Trump's order. I mean, clearly that's not the issue here. It's the determination by the executive that there is obviously national security interests that are involved here. And in those areas, the judiciary shouldn't disturb it, and especially where there's not been a showing of a likelihood to succeed on the merits. The professor noted that it's a chance of success. No. In order to get the injunction, they had to show a likelihood of success.
All right.
And in fact, the district court judge doesn't even bother to comment on that in his very brief order.
All right. Joe Miller, Executive Director of the United States Justice Foundation, thanks so much for joining us.